everyone. I am Kate Kalmykov, the co-chair of the Global Immigration and Compliance Group at Greenberg Traurig. Welcome to the Immigration Insights podcast and videocast, and I'm delighted to be here for our third episode today with my colleague from our Labor and Employment Group, Galit Kierkut. Hi, Galit.
Hi, everybody. Hi, Kate. Thanks for having me.
So today we're going to be talking about the intersection of employment and immigration law in the employee hiring and termination process. That's probably a topic that we could talk about on 5 podcasts if we really wanted to. There's a lot of nuances here, a lot of state-specific requirements, as well as federal immigration law requirements. But why don't we kick it off by discussing what is employment at will?
Sure. It's a highly misunderstood topic, actually. Employment at will officially means that both the employer and the employee have the right to terminate the employment relationship for any reason at any time, with or without cause or notice. So we don't have, servitude in this country, and people can leave a job. They can quit without notice if they want to. It's not considered professional. And the employer also can terminate and say to the employee they have to leave that day. So that's what employment at will means. One thing I get asked regularly when I'm counseling on employment issues is, well, if there's employment at will in this country, which there is, unless there's a contract that says otherwise, if there's employment at will, then why do I have to think about all these other issues when I terminate? And it goes a little beyond the scope of what we're talking about today, but there's a lot of other issues that you have to think about when you're going to terminate someone. Discrimination, retaliation, there's lots of different reasons where you might want to wait or want to give warnings or things like that before termination. But officially, the rule in the country is employment at will, and most states follow that.
And interestingly enough, we also often get asked by clients, do I need to have an employment contract to sponsor an employee for a visa, a work visa? And the answer is no. There is no visa category that requires an employment contract. Employment at will, as Galit said, is accepted practice in the United States, and obviously immigration accepts that as well for any foreign nationals that a company is going to sponsor. Now, what are some considerations that we should think about when we're interviewing someone for a job? So are there certain questions that we can ask, can't ask, and what should we be focused on, Galit?
First, I want to make sure that everyone understands that when they're interviewing or in the whole hiring process, it's really important not to make any promises that are inconsistent with employment at will. So, and that usually kind of comes up in the interviewing process. So you don't want to say things like, you're going to have a job here forever, or you as long as you do the job well, we're going to continue to employ you, or anything like that. You don't want to make promises that are inconsistent. And it's also a really good idea in your offer letters to state the employment at will rule that I just kind of stated, and to make sure that it's very clear to employees that the employment is at will and can be terminated at any time. And when you say employment contracts, Kate, it's definitely true that you don't need to have an employment contract to hire someone, and nor do you for immigration reasons. But there are certain types of agreements you do want to make sure to have with employees regarding confidentiality and things like that. So and in those types of agreements, it's a good opportunity again to restate the employment at will construct. So I just wanted, before we get to interviewing, to make sure that that's clear.
And that's a great point. And you and I often work together where I'll take a look at someone's offer letter to make sure that it's immigration compliant. Often we see sometimes employees are very much pushing to have a sponsorship. And so they're obligating an employer to make promises that they're not allowed to under the immigration laws in these offer letters. And you're reviewing it to make sure that it's compliant with relevant employment laws. So I think that it's very important to work with counsel, both if you have a foreign national and you're sending an employment, offer letter to them, and with employment law counsel, as well as you said, for other agreements that you may have with them.
Yeah, absolutely. Agreed. And so in terms of interviewing, other than the employment at will issue in interviewing, there's, I alluded before to all the exceptions to employment at will, and they're not really exceptions, but they're just other considerations that you have to make and have to take when you're thinking about terminating someone. And those same considerations play in to the interviewing process. We have all sorts of laws prohibiting discrimination in this country, right? And the states have various laws that go even beyond federal laws in a lot of states. And so there are a lot of questions that would relate to what we call protected classes. Um, that you're just not allowed to ask in the interview process. And you're also not allowed to look for before you interview them. So, when you're doing kind of your research on a candidate, even pre-interview, there are things that you're really not supposed to be relying on. You're not supposed to be asking questions about age, other than to say, well, are you over 18? In places where that's the requirement in terms of age. In employment, you're not allowed to ask, even if someone owns their home, you're not allowed to ask about religion. You can ask about work schedules. So you can say, do you have any limitations on your work schedule? But you can't ask the pointed question about someone's religion. Um, Accommodations is another very important issue that people often get wrong, particularly if someone has a more visible disability. You can't ask any disability-related accommodation questions until after an offer is made. And after an offer is made, you can enter into, and you have to enter into the interactive process if someone needs an accommodation, but that can't be done till after the offer is made. So you really want to ask about, you also can't ask about family status. Do you have kids? Do you need to leave early to go pick up kids? You can ask again about work hours. So make the questions, not personal, focusing on the work history, skills relevant to the job that has been applied for. No promises of salary increases. Don't make promises you can't necessarily keep in the interview process. Criminal history is another one that, this varies state to state in terms of exactly what questions and what you can do with respect to criminal history and criminal records. But the EEOC, which is of course federal law, um, has talked about the request for criminal history as potentially discriminatory. So even in states that don't have specific prohibitions, and a lot of states do, again, about asking about criminal history, policies against hiring people with criminal histories can be discriminatory. And again, you have to have an individualized assessment of each applicant. So, that means, and even for states that have those types of prohibitions, you certainly can get a criminal history as part of a background check after an offer is made or is a contingent. So an offer can be contingent on a background check. And that includes a criminal history. And sometimes the criminal history will be relevant to the job. So, for example, you're hiring someone as a CFO and they have a history of embezzlement. Well, that's relevant to the job, and you certainly can refuse to hire a CFO who has a history of embezzlement when they were convicted for embezzlement within the last however many years. So, in really any state. So but they're individualized assessments. So you have to be really careful about criminal histories. And I know there are immigration consequences to that too.
Absolutely. And in the interview process, often people think they can't ask if someone requires immigration sponsorship, but you can, because a company may not ask what someone's immigration status is. But if they hire someone that they're required to sponsor, they're going to have to outlay money to do so. Immigration sponsorship requires legal fees, payment of USCIS or Department of State filing fees. So you can absolutely ask, do you require immigration sponsorship? And if someone discloses that they have a criminal history and they responded affirmatively that they do require immigration sponsorship, you can absolutely ask for more detail about the crimes, because certain crimes will invalidate someone's ability to get a visa status in the United States. There's fraud crimes, which do, there's domestic violence, which does. So it's very important to get this information up front because we don't want to have an employer in a position where they're spending money to sponsor somebody and then they find out, oh, this person has 3 DUIs, he's going to be inadmissible.
That's the intersection again. And and then of course we move to salary, which is another kind of thing that, generally people talk about in the interview process. And that has a lot of implications, both on the employment side and on the immigration side as well. Um, so the compensation with a prior, there are a lot of states now that have prohibitions against getting wage history and salary histories. It's not every state. This isn't a federal issue. But there are a lot of states that do have that. Certain states require you to, in the job posting, to set the salary range for the job. So not to ask someone what they were making, but this is what we're paying for this job, regardless of what your prior salary was. And so certain states have that requirement. And so really what you want to ask during the interview process, this is relevant again to that conversation, is what are your salary requirements rather than asking what were you making at your last job? Because there's definitely a trend in terms of moving away from that kind of discussion about kind of what your salary history is versus your salary requirements. And the reason for that is because of concerns about equal pay. So we can get more into that, but I know that there are issues related to immigration on that front as well.
Absolutely. So this is something that we really need to take into account, particularly when employers do labor certification to sponsor their employees for green cards. We are looking at things like wage ranges. But I have a question for you, Galit. If we have an employer that's a large scale employer with operations in multiple states, do you generally advise them to have a uniform policy with respect to how they're interviewing and asking these questions? Or does it make more sense to adhere to state by state requirements?
Really depends what the issue is for interviewing, and staying away from certain kinds of questions. Mostly we advise to have one policy that's the most strict policy, but sometimes the most strict policy is really not going to work in some states. California has some crazy laws, and we really want to impose all of those laws on every state. So sometimes we'll carve out the most difficult states, and say, okay, well, this is what you do in those states. It is really important for certain issues to make sure that you're compliant with the state's laws. Offer letters have some specific requirements in various states. Confidentiality, non-solicit, non-compete agreements have very specific requirements in certain states. So if you're doing those kinds of contracts, and using them regularly, it is really important to get them reviewed for state compliance.
Now, you talked a lot about equal pay for equal work, regardless of gender, and there's no basis for disparity. There's also a concept in immigration law when we have employees sponsored in certain categories, most commonly the H-1B, where we don't want to displace US workers. So we want to both protect the foreigner, we want to pay them the same amount, the minimum that the Department of Labor says is appropriate in that position, in that geographic area. We call it the prevailing wage. So they have to be paid at least that. And we do that because we don't want to displace US workers. So we want to not exploit foreign workers and we want to protect US workers from being displaced. So a lot of these requirements overlap between immigration and employment, and it's quite interesting.
It is, yeah. Equal pay is definitely the reason that a lot of these wage disclosure um rules went into effect, and specifically the ban, the requirements to post the range. Because the concern is that if you're just asking people what they made and you're basing an offer on that, you're just perpetuating the unequal pay that they started with in their career, and then there's never going to be any change.
And I read actually an article recently that said that women are less likely to ask for what they think is appropriate as their wage in interviews versus men. And so I think here the federal
100%.
laws are taking that into account as well.
100%. And and there is a requirement to make sure that you are equally paying along gender and race lines. And so a lot of companies, a lot of our clients are doing audits, internal audits to ensure that their pay scales are equivalent. And there's all sorts of exceptions in terms of, um, really making sure the jobs are equivalent. And smaller companies, you don't have a lot of equivalent jobs, but larger companies you do. So for smaller companies, it is definitely harder to kind of implement that.
So how do you perform these audits? This is interesting. I haven't spoken with you about that before.
Well, there are companies that really specialize in doing that. We tend to outsource that. We won't, generally do that ourselves as a law firm because it's not cost effective. But there are a lot of companies that really perform these audits, and what they're doing is they're looking at the job descriptions. It's also a great idea to do a job description audit for other reasons, for exempt and non-exempt status and those types of things. But it can all be part and parcel of the same thing when you're looking at the job descriptions and what the pays are, but then you are looking at what the actual pay is for the people who are in that job and what the differentials are. And if you see a real percentage differential between men and women or between people of different races, then companies are doing resets and they are increasing the wages of the folks who are not making as much as they should be making. And so that's been going on a lot. And what that does is avoids the government coming in and doing it for you. And the lawsuits and the, attorney's fees and the treble damages and all those kinds of things.
And obviously, it's very important for our clients to avoid that. Now, let's say we've interviewed someone, we've sent the offer letter, they've accepted, and now we're ready to onboard them. What are the employment law considerations that we should be taking into account when we're onboarding someone?
The onboarding process really is more in your area than in mine because there's a lot, we do the background checks. That's kind of one of the things we talk about pre-offer accommodations. If they need any accommodations, that's the time to kind of discuss those issues. But the immigration and the I-9 and the E-Verify is, definitely the key thing that our clients have to do during that onboarding process.
So this is a requirement most people sort of dismiss. They think it's a, one-page form. It's not a big deal, but it is. So the Immigration Reform and Control Act of 1986 required that all employers within the first 3 days of hire complete a Form I-9. And the goal of the Form I-9 is to verify an employee's eligibility to work and their immigration status in the United States to make sure that they're lawful to work here. Now, the I-9 has to be completed by everyone, U.S. citizens, U.S. permanent residents, and foreign nationals. And it has to be completed by HR within the first 3 days of hire, but the employee themselves has to complete Section 1 on the first day of hire. So one of the things that I do a lot of work in is audits of I-9s, where the government comes in, and usually it's Immigration and Customs Enforcement, ICE. They have a very scary acronym. They give you a notice of inspection, and they say, give us all your I-9s in 3 days. And they want to see if mistakes have been made. And I have done so many audits in the last 20 years, and I have never done one where an employer has them all done correctly, unfortunately, because perhaps HR staff isn't trained on it. Perhaps they're not reviewing carefully. Perhaps they're just not completing the boxes, not completing the sections of the I-9, and it happens all the time. It is very important for all of the boxes to be completed in Section 1 by the employee. If they're not doing that, they have to be called back and told to do that. critical. Here in Section 1, they attest to what their immigration status is in the United States. They attest to their identity. They attest to their work eligibility in the US. And in Section 2, the employer is verifying that information. So they have an obligation to review documents provided by the employee and make an attestation in the form that they have reviewed it and that the person is work eligible. Now, here the rules are very specific. We can't tell employees what documents to provide. That can be considered discriminatory. We can't over-document an I-9 in the hopes that we're going to be super compliant, right? I once did an audit of a company and they said, well, for our American employees, we just tell them complete List A documents, but we have a large Latino population and we tell them to give us documents from List A, B, and C. We're super compliant. And, I said, no, can't do that because what you're doing is discriminatory. And here, we definitely can get pinged by the DOJ because you are imposing an extra requirement of people of a different nationality or citizenship. So we absolutely cannot do that. We can use one List A document, such as a US passport, which shows both your identity and your work eligibility, or a List B and C document, for example, a driver's license and a social security card. Foreign nationals are always completing List A because they're using whatever document they get for their work authorization in the United States and presenting a passport in some cases to prove who they are. So if your I-9s are not in order, if you haven't looked at them in a long time, please do a snapshot audit because when ICE comes in, they're coming in to generate revenue for their agency. And for every single error on the form, they can impose financial penalties, and the penalties really add up. And in egregious cases where, for example, employers have employees on their workforce for which they haven't completed an I-9, they can get charged with criminal penalties. And in really egregious cases, we've seen that ICE and DOJ have sought to prosecute people under the RICO statutes for racketeering, for harboring illegal aliens, and those are serious federal charges. So no one thinks about the I-9 because it's this one-page form, but it's very, very important. And this past year, USCIS issued a new form, and they know that a lot of people are working remotely post-COVID, and now they've given employers the ability, if they're registered for E-Verify, which is the government's federal online registration system, which allows you to do the I-9 verification online through the USCIS portal. And that USCIS portal will tell you once you put in an employee's information, whether they're work authorized, whether they're not work authorized, or whether there needs to be a further confirmation of their work eligibility. If you're registered for E-Verify, you can now do the I-9 process remotely over Zoom. So that is something that is very welcome because during COVID, we had an exemption. That exemption went away and people were really scrambling because now they've hired people all over the country and they're on their payroll, but they don't necessarily have an office where they're located. So this is something that was very, very welcome.
Speaking of those people, Kate, also on the employment side, it's very important to make sure that if you have folks who are working remotely in some state that you don't usually do business in, that you are complying with the employment rules of that state for, as I said, offer letters. We're going to talk about terminations, so for terminations. And it's really important, and I know how the way they're being paid. Also, leave issues vary widely from state to state. So it's something you want to also make sure that you're doing properly. And in terms of audits, I mentioned this earlier when I said, wage and hour audits. And one of the things that when you're hiring someone, you need to decide whether that person is exempt or not exempt, whether the position that they are in is exempt or not exempt. And you can't assume that just because it's a white collar job, that the person is automatically exempt, or just because you're paying them a salary, that the person is automatically exempt. The exemption is related to their job duties, not to only whether you're paying them a salary. They have to be paid a salary if they're exempt, but they also have to have job duties that justify the exemption. So that's another thing that companies get wrong all the time. And it's another good area for self-audit because just like with the I-9s, I have never seen a company that hasn't made a mistake. And we really help companies, self-correct there before the government comes in. And these fine, they're not just fines, there can be certainly individual liability, and criminal penalties as well there. So I would be remiss if I didn't mention that.
Self audits are key. I mean, in the I-9 context, we have saved our clients from criminal charges, from
Okay.
hundreds of thousands of dollars in penalties. So it's really key. And I think that's a very good point on the remote work, both in the I-9 context, but in the visa context. We got a case that was handled by another law firm last week. And in the H-1B process, you actually have to do a posting that you're sponsoring an H-1B worker. And we had someone working remotely. And so what we do in those cases, we make the person post in their home to meet the DOL requirement of giving notice. It sounds silly, but we photograph it, we put it in the compliance file, and if there's a public access file audit by DOL, we have proof of posting. They had been working with counsel that said, just put the employer headquarters on the petition. And this person's working in California and the headquarters are in New York. Can you imagine if they're audited of the liability? So it's very, very important to get up to speed on remote work and the requirements associated with that. And that's probably the subject of a whole other podcast.
For sure.
So with E-Verify, just a couple of points that I want to add. When you're entering into E-Verify, into the online system, there's benefits to it because, for example, you get to keep STEM graduates longer on an EAD, so you don't have to sponsor them. They can get this EAD work authorization card, but you are entering into a memorandum of understanding with ICE. So it's very important before you do that you work with counsel to do an internal audit of your existing I-9s. We don't want to open our books to ICE and have ICE find a lot of mistakes. After you enter into the MOU, you get a safe harbor by joining E-Verify as an employer. And this is important because more and more states are now requiring the use of E-Verify. Florida made headlines last year because it became a requirement for any employer that has over 25 employees. And of course, federal contractors have been required to use E-Verify now for many years. So let's move on from the onboarding process to the employee problems and termination process. Galit, what do we need to be aware of here?
So remember when I said at the beginning that employment at will isn't really employment at will? Well, that really comes into play when you're talking about performance issues and terminations. Because there are so many protected classes today, both federally and statewide, it's a rare employee that does not fit into a protected class. Pretty much everyone's in a protected class. When I do training around these issues for our clients, we list out all the protected classes, and I say, look around the room. Is there anyone who doesn't have a religion, a familial status, gender, over 40, some kind of disability? There's lots and lots of protected classes. So because of that, there's potential liability if you terminate someone, and the person claims that the termination was because they're in a protected class. So that always has to be kind of in the back of an employer's mind when they're looking at terminating. And so because of that, it's really important, we say HR 101, consistency, consistency, consistency. It's very important to enforce work rules and standards consistently, because that is going to be your number one defense in terms of these types of cases. If they're brought, is, well, we had consistent rules, this person broke the rules, and therefore they were terminated. We have consistent performance standards. The salesperson has to make this much, this many sales per month, and we are consistent. If someone doesn't meet those goals, they get a warning, they get another month to improve, and then they're out. So as long as you're applying these rules and these work standards consistently, you have a much better defense against any of these types of cases. It's really also important that you document. So I can't tell you how many times I get the call from a client saying, well, we want to terminate this person. They fall into 6 protected classes. And we've told them that their performance is not acceptable, but we don't have one email. We don't have one piece of paper that says that. And I say to them, well, it's nice that you've had conversations with them. They're going to say you didn't. And you have no documentation. And they're going to potentially be able to say that this termination was discriminatory. So documenting is very important. But again, document consistently. Don't, it's very obvious when you're trying to terminate someone and all of a sudden you start documenting. So the documentation has to be, over time and consistent and not just targeted on the person that you have chosen for termination. Because then they're going to be able to say that that was pretextual, and that's helps them establish a discrimination case. So be careful not to over document. When you are working with counsel or even with HR on these types of terminations, remember that things that you put in emails. So for employers, they're working with HR and counsel is not involved, whether inside counsel or outside counsel. And you're discussing an employee and a potential termination in an email. That email is not privileged. That email is discoverable in a future lawsuit. So be really careful about what you put in writing and making sure that if you're requesting legal advice, it's clear on the email that you're requesting legal advice, because then that becomes a privileged conversation. And just be mindful of privilege issues, because when it comes to terminations, I mean, I litigate these issues all the time, and what is put in an email will come back to haunt the employer later on if they're not careful.
These are very good points, Galit. And of course, on the immigration side, there's a number of steps that we have to take, both for the employee being terminated, but also when we're considering our immigration programs in general too. Because for the particular employee, we may have to withdraw their approval with USCIS or the Department of Labor. We also have to talk to them about their status, because they'll have a limited amount of time to remain in the United States and then they need to leave. The situation gets more complicated if they're in the midst of a green card process, which they may lose, or depending if they're further along in it, be able to what we call port to another employer. So those are things we have to take into account. But interestingly enough, if an employer performs layoffs or reductions in force, then we may be barred from doing green card sponsorships for about 6 months until after the layoff. So we have to think about how is the termination occurring, what are the circumstances, and absolutely discuss that with counsel. And sometimes as immigration lawyers, where we've been involved in reductions in force, we've been involved in layoffs, we are in the room with HR counseling them on how to respond to the employee when they're one-on-one with them. Issues also arise with garden leave. Can't do it in the immigration context. You've made an affirmation that you're hiring that person and they're working for you, whether it's part-time or full-time. You can't just put them on garden leave. It's a big no-no, especially this happens in the H-1B category, and it can debar employers from sponsorship in the future.
And garden leave is used so frequently, particularly if you are trying to enforce a non-compete in certain areas. And so these are the times, Kate, you and I work so closely together when we have an employee who they're trying to enforce a covenant, but yet there's an immigration issue, and we are trying to put a severance agreement together. And you need employment counsel and immigration counsel to work together closely on those issues to make sure that you're covering all of your bases.
Absolutely. So with that, I want to thank you, Galit, for appearing on Immigration Insights. I think this was a great, fascinating discussion. I look forward to having you back on the podcast to delve into these issues in more depth.
Thanks so much, Kate. It was a pleasure.